Good morning to everybody. Welcome to the today class of the Muslim law. That is the classes for the appearing the regular student for the examinations. Yes, please. Okay. Oh, there are a lot of disturbance. So mute the people. Those who are open it. Please mute it unless until I ask you. Don't unmute it because I am getting a lot of disturbance. Perhaps maybe somewhere where the disturbance is more. I believe. Yes. And if you could happen to see that. What I have cited on the screen, please, anyone can unmute and read. Anyone, I said. Anyone can unmute and read what I cited on the screen so that I could go ahead. Yes, please go ahead.
భయపడి చెవులు మూసుకుంటే మన కోసం గెలుపు కొట్టే చప్పుడు మనం వినలేము. శుభోదయం.
Yes, very good. Thank you very much because that you know that భయపడి చెవులు మూసుకుంటే because don't fear if it and close your or the ears because some people wants to give the encouragement to you that you lose the chance of the clappings. That's the thing which is there. And now I will come to the because the last class that I told you that I am going to give the a detailed description about the gift that is called Hiba. So let us see the what is Hiba. There is a gift. The pack which I have shown here is a gift. It is a Muslim law terminology. We will say Hiba. So let us see that what is Hiba. Then the definition of the gift. Then we will see the valid gift. What are the essential requisites for the valid gift? Gift formalities, revocation of gift, kinds of gift. This is the thing which, but I added the gift to minor and doctrine of Musha also there because sometimes it will be asked in the short questions. Doctrine of Musha and comparison of the will and gift, both the things also there. So let us see the introduction. A Muslim can devolve his property in various ways. Devolve in the sense transfer the property, and this is one thing in the from the higher level to the lower level. That is also another meaning of the devolve. And a Muslim law permits the transfer of property inter vivos. There is a gift who are the persons who are the living persons through testamentary dispositions. That is the will. A disposition inter vivos. There is a Latin term between the two living between the living organism because generally the giver and taker would be there. That's why that is a two living organism is unrestricted to a quantum and a Muslim law is allowed to give away his entire property during his lifetime by the gift. Then again, it is a disputable question is that because in the Muslim law, this is the entire property can be given the gift. Then what will happen to the wife, valid wife, or the children? If the theory says like that, that's why that we can say that some of the places the theory is different and the practical is different. That's as I told you that a Muslim can marry the four at a time, but can it be possible nowadays at this juncture and the digital India, the four keeping the four wives? It is not those days where our forefathers would be having the keeping the four wives because now with the one is equal to four. That's why the only one wife would be there, though the theory will give it, but practical is a different thing. So only one third of the total property can be bequeathed by will. But a gift can be given by entire property. But when you come to the matter of the will is concerned, only one third will be given bequeathed by the will. Of course, there is a story also wherever the regular classes was there. I was told the story between the Prophet Muhammad and the Sahaba. The one of the Sahaba, the dialogues also, where the will would be given, how much the will be given. Then the Prophet has allowed only one third at the time. A gift is a transfer of property where the interest is transferred from one living person to another and without any consideration. Of course, in a gift, there is no consideration because the consideration is the love and affection is only the consideration, and it is gratuitous, means free of cost, without any cost or money. That is called the gratuitous and interwoven in nature. This is a general definition that is accepted by all the religions, including the Muslim law. As per the Muslim law, a gift is called as a hiba. There is a terminology called Hiba, Hiba, Hiba. Suppose if the question is asked in the Hiba, what is Hiba? Or kinds of the Hiba, if they don't be confused, Hiba is nothing but gift. Sir, that word is not there in the syllabus. No, sir. Okay, the word is not there in the syllabus, but I am giving you. But generally, nobody will ask the Hiba. They will ask only the gift. So under Muslim law, the concept of the gift developed much during the period of this 610 AD to 650 AD. In general, Muslim law draws a distinction between a real and the personal property, and there is no authoritative work on the Muslim law, and which affirms the Muslim law recognizes the splitting of the ownership of the land into the state. What Muslim law does recognize the insist upon is the distinction between the corpus of the property itself, called as the ayan, and the usufruct is the property is called manafi. So Manafi is the usufruct and the property corpus is the ayam. Then under the Muslim law, religion of the person to whom the gift is made is not relevant. So a gift can be given to a non-Muslim also. In India, there is a separate statute governing the matters related to the transfer of property. The Transfer of Property Act 1882 under the chapter 7 talks about the gift and the procedure for making the same. At per section 129 of the Act, the Transfer of Property Act 1882 does not apply to the Muslim making the gift. Of course, 129 is not applicable uh, to the Muslims because there is a personal law. So the definition of the Hiba, that is a gift we have seen, it is nothing but the interviews, it will be given between the two parties and there would not be any consideration, there would not be any condition, that is they call a gift. But let us see that what the Shia holds, that a Hiba is an obligation by which the property, the specific object is transferred immediately and unconditionally without any exchange and free from any pious and religious purposes, the part of the donor. Muslim law allows the Muslim to give away his entire property by gift interviewers. Again, I say the entire property theory that is practically done, even with the specific object of this inheriting his heirs. And please refer the case of the Abdul versus Ahmad that is clearly mentioned over there. One cannot give the property entirely to the in the form of a gift by inheriting their own kith and kin. Yes. Furthermore, of course, I have given the citation over here. According to the Hidayah, what they say about the gift, that is the Hiba is there an unconditional. See, there is not be any condition when you are giving the gift. It is there an unconditional transfer of ownership in an existing property made immediately without any consideration. So the ownership will be transferred in the gift and plus unconditionally the another thing between the living person, the another thing, and immediately without any consideration. There should not be any consideration in the consideration in the form of the price because it is given in the love and affection only. A gratuitous act that is. According to Amir Ali, he is one of the author, the good author like Mullah, and a hiba is a voluntary gift. It is a voluntary gift without a consideration of the property by one person to another person as to constitute the donee, the proprietor of the subject matter of the gift. So the donor, the person who gives the donor the gift, and donee is the person who receives the gift. So here the donee, the proprietor of the subject matter, that is a gift, and he should be the absolute owner. So according to the mullah, is one of the propaganda of the Muslim law. According to the mullah, what it says, a hiba is a transfer of property made immediately and without any exchange by one person to another person, accepted by or on behalf of the later. So the other person should have to accept it. Suppose if we did not accept it, for instance, you take a minor cannot give the consent over there, but at that instance, on behalf of the minor, the natural guardian or the legal guardian or guardian appointed by the court or whatever it may be, that what we read yesterday would be accept on behalf of the child. According to the 5Z, Hiba is the immediate and unqualified transfer of the corpus of the property without any return. So these are the different people definitions will be given regarding the hiba, that is the gift is concerned. Let us see one of the example case law, that is the P Kunhima Umma versus Ayasa Umma. There is the AR 1981 Kerala 176. The Kerala High Court held that the requirement of the immobile property under the Muslim law are whatever the requirement for the immobile property under the Muslim law are, which is clearly stated in the case law. There is a declaration by the donor, it should be must. And next, acceptance by the donee. The donee should have to accept it. Is provided the donee is a capacity to contract. And number third, delivery the position by the donor to donee. So delivery also be an important factor. So declaration by the donor, merely not the declaration, intention to pass on the property to the donee also will be taken into consideration. Then acceptance of the donee also an important factor, and there will not be any condition at all whenever a person is giving the gift. However, there is no consideration and necessity to transfer the possession immediately, distinguish the gift from the sale. But the sale, it may be the made later part, but the gift, the immediate transfer of the property should be there in the gift. So, silent features of the Hiba. What are the silent features of the gift? Let me see it. Number one, Hiba is the transfer of property by act of the parties. So, one party to another party by operation of the law. By operation of the law also can be done, or the individual can make it out. It means that any transfer of property done by the court of law or by transfer of ownership, the Muslim law of inheritance will not be considered as a hiba. So what it means is, suppose if an action is there or if any other property is transferred by the court of the law, at that instant it is not set with a gift. It is given because to clear the debts of a particular person or action, it will be sold to somebody else, and the only debts will be paid, and the rest of the amount will be given to the owner of the property. So here, what I want to say, the one party to another party, but the action and the court made such a thing which is not set to be the gift, because the gift should be given by the donor to the donee, and that to be without having any condition, with the love and affection will be there, and property should be transferred and unconditionally. Yes, under the Hiba, a living person voluntarily transfer the ownership of any property to another living person. Hence, it is a transfer is inter vivos. That's why we will say inter vivos means between the two living organism or two living persons. Number third, the transferor transfer the ownership of the property in absolute interest, and the transferee gets the complete title in the respect of the property given to him. Conditions that restrictions or partial rights in a general in the gift property are averse to the concept of the hiba under the Islamic law, provided there should not be any restriction, the partial or the quarter or whatever is the manner, there should not be any condition in transferring the property to another person, that should be physically from the transferor to the transferee. And here I would like to see the who is the transferor, who is the transferee in another terminology. In the gift terminology, anyone can unmute and give me the answer. Yes, I would like to test. What are the other terms that can be used for the transferor and transferee in the gift that is called hiba under Muslim law? Anyone can unmute and give me the answer.
Sir, again, question again, sir.
Here the gift, and we are reading, and we are saying the transferor and transferee. What is the terminology can be used in the gift for the transferor and transferee?
Sir, Musha, can we call Musha, sir?
See, that is a different. See, why don't you say clearly donor and donee?
Yes, sir.
Is it a tough question? Just I want to see that whether you could follow the point or not. Suppose if you forgotten the transferor and transferee, then you can say the donor and donee also, isn't it? So that is the point what I want to make it out. Suppose if you could not know the particular word, then you can use the another word which is very much suitable to convey your idea. So hiba is operative with the immediate effect and deprive the transferor, that is the donor, of his control and ownership over the property. Moreover, the property is passed immediately to the transferee. So the question is not future transfer. You should be immediately transferred to the property. If it is a immobile from, okay, immobile from it, the paper should be transferred immediately. The property must be in existence the time when the gift is made. Another point is in the will, the property may not be in the existence when you are the person is making the will, but whenever the person is going to give the gift at the time, the property should be in the existence, and he should be the sole owner of the property also. Otherwise, I used to say atta sommu alludu danam chesam. It cannot be done over there because the alludi is not the owner of the property, which the property belongs to Atta. Okay. A gift made for the property which will exist in future is termed as void. So, in the future property that I am going to give you the form of a gift, that it cannot be done over there. Of course, there may be some gift would be there, but generally the gift should not be having any condition. Unconditional things or a transfer is called a gift, that to be the love and affection without any consideration from one living person to another living person. Then the last point is the hiba is a transfer of property without any consideration. If anything of the any value is taken by the transferor in terms of the exchange, such a transfer of property is not a gift. If any coin or even though the coin the value is less also, if it is taken in consideration, that is not said to be the gift. That is the hiba. Of course, the requisite of gift, I say ingredients of gift, I made it there, but the following the essential of the valid gift, because the party should be there and there should be a subject matter and the extent, how much the extent would be there, where the entire property or the property with the condition without conditions and formalities of a gift, there the gift should be transferred over there physically, and the parties to the gift, there are two parties of a gift, that the donor and a donee. The person who makes a gift is called a donor. Most importantly, the donor of the gift must be have attained the age of majority as governed by the Indian Majority Act 1875, because the person who is giving the gift, who is the donor, he should be the more than 18 years, means a major, and must be a sound mind and free from the fraudulent nature and influences, must have the ownership over the property which that he is going to transfer by way of a gift. The rule of the Muslim law of the majority is attainable of the property does not apply to the gift. It should be completion of the 18 years after the child under the custody of the 18 years completion is the ordinary sense, but the child under the custody of the guardian and then the guardians under Ward Act 1890 say the child should be crossed 21 years. Beside this, a gift by a married woman or Pardarashin lady also there. A Pardarashin woman is the woman who observes the rigid rules of the seclusion by wearing the veil or burqa, we can say, considered the valid, but the burden of the proof is to be proved that it was done it was not by the undue influence, and the nature of the transaction lies on the donor. Such a women have been given an extra protection in order to prevent their rights and interests. I am speaking with the Pardhanashin lady. However, the rules of the transactions apply equally to illiterate and ignorant women Durat Pardhanashin. So a person who wants to give the gift need not to be educated person. A person who wants to give the gift need not to be, what is it? You should be a sound mind. That is a very important factor. A person who want to give the gift, that is the donor. Yes. In the case of Hussein Bai versus Zohra Bai, that is the validity of the gift made by the Pardhanashin lady was declared by the court. In this case, a Pardhanashin Muslim lady was brought from the Nagpur to the Burhanpur on an excuse that her brother-in-law was seriously ill. With that pretext, she was brought from the Nagpur to the Burhanpur. After reaching the place, she had a fit of hysteria, and soon after it, she has made a sign of the gift deed without informing her content of the deed, and no opportunity was given to her to take an independent decision at that instance. When I was in hysteria at the time, and she could not know what she is doing, and forcefully they have taken the signature of this lady on the documents at the court held that when a gift is made by the Pardhanashin lady, she is the Pardhanashin lady with the secluded form and wearing the burqa and hijab. It is important to establish that the consent of the lady was free, and she made a gift on her independent advice. The burden to prove that the gift was made were free from compulsion lies on the donee. In this case, the deed was executed from the lady under the compulsion. It was not her voluntary act, hence the deed was held invalid because the deed was signed by her forcefully when she was undergoing the hysteria, or when she had a fit of the hysteria, which deems to be the unconscious, or you will not know what she is doing at the time. Yes, and a gift is made with an intention to defraud the creditors. Yes, people will say that because the creditors are more over there and they would like to attach the property, and this fellow wants to give the form of a gift to somebody else. At the time, the gift is not a valid gift because disguised form of transferring the property in the form of a gift to somebody else, so that the creditors will not get anything from this debtor. The gift is invalid. That is observed in the Abdul versus Muir Muhammad. That is the case law. These cases are decided under the Hindu and Muslim and the Muhammadan law respectively, but they illustrate principle. In a Calcutta case, it was said that the release of a debt is not a gift, as a gift must be of tangible property, and if submitted that the release of the debt is not a gift, as it does not involve a transfer of property, but is merely a renunciation of right of action. So, in the form of a for the completion of the deed. I mean, the set of the debt, if you want to transfer the gift, it is not a set of, it is not a gift, it is only the renunciation of the right that you are transferring to somebody else because that much amount is due. That's why that you are giving the gift of that property to him. We is not with the love and affection, but to clear the debt. So that's why we can say the right of time is the renunciation of the right of action that we can say. Then financial capacity, according to the Hanabila, if a person under the insolvent circumstances he is allowed to make a gift. However, Qazi has a power to declare any gift as void if it is made with a view to defraud the donee. Yes, if the donee wants to defraud over there at the time the gift is void. The Indian courts have accepted the view of the Hanafi school that from the fact of the indebtedness or embracing the financial circumstances of the donor, it cannot be inferred that the donor has fraudulent intention. Of course, if the fraudulent intention, if it does so, then definitely it will not be a valid gift. So, in every gift, there must be a bona fide intention on the part of the donor to transfer the property to the donee. That should be must. Evidently, the gift is made with a bona fide intention to defraud the donee. The gift is invalid. With a bona fide intention that suppose somebody wants to give the transfer the property in the form of a gift to avoid the creditors at the time that gift is invalid. So now that is about the donor. Let us see the donee. How the donee should be there. The person who makes the something the gift is called the donee, and it is noted that the sex, age, creed, and religion are no bar to the gift. A Muslim is even allowed to make a lawful gift to a non-Muslim, such as a Hindu or Christian, however, it is important that the donee must be in existence alive at the time of the gift. That is a very important factor. A person that who are receiving the gift called the donee should be alive. If the donee is insane or minor or a lunatic at that instant, then the gift must be given to his legal guardian. Giving possessions to mother or brother or a donee is not the legal guardian will make the gift void. So I repeat, giving possession to mother or brother of a donee is not the legal guardian will make the gift void because they are only the custodians. Therefore, the principle follows that a gift to minor by any person other than the minor must be accompanied with the delivery of the possession to the father or the guardian of a minor, who are the real guardians, or the natural guardians or the legal guardians. So an unborn person, can an unborn person will get the gift? Then the question is, gift to an unborn person is considered wide, but a gift by a father to his minor son is valid. This was seen observed in the Brahmin Shah Muhammad versus Noor Ahmad Noor Muhammad. Earlier, gift of the future usufruct to unborn person was not considered valid, but later this was, however, not followed. If a gift is given to the unborn person, such a person born within 6 months, condition is he should be born within 6 months, then such a gift is valid, gift as per the Muslim law. Because after the 6 months, if he given the delivery means, that means he conceived already, uh, that the 3 months would be there. So he conceived already, the cycle will be suspended, so that it will be confirmed in the first month or second month, or finally the third month. At that instance, we can say within the 6 months, if the child is born over there, and such a gift will be a valid gift. A child in the mother's womb is a competent donee, provided that it is born alive within the 6 months. The condition is there. When the child is in the womb of a mother, in the form of a fetus, at the time also he was entitled to get the gift, provided he should be alive at least after the 6 months. Means delivery should be 6 months and should be alive. At the time that you will be entitled to get the gift. If after the declaration of the gift the child dies in the womb and an abortion take place, suppose the child dies in the womb after the declaration and abortion take place, the gift becomes void automatically because the child is no more in alive. And also the child must be in existence in the mother's womb at the time of the making the gift. Just I told you, no, the 6 months born after the delivery at the teens, definitely he is conceived in the mother's womb. Means conceived. The fetus will be there at the time. If the child is not in the mother's womb, suppose if she is not conceived, the conception take place after the declaration of the gift. Such a gift is void of an issue. Suppose without the conception would be there in the mother's womb, if the declaration is made, it is a ab initio wide. After the conception, if the declaration is made that he is going to give it that gift, then it is a valid gift. So let us see the mask. Can a mask or any other institution considered as a juristic person? Thus, they are the considered to the competent donee. So here also the question comes. Of course, a juristic person also will be say the living person here. So another is the fiduciary relationship between the teacher and a student, and between the presumption is that and a father and children and the doctor and the patients. Such a relation should be there at the time. The donor and donor and the fiduciary relationship. In the relation is said that one of them is dominating them. In the case of the dispute, the presumption of the undue influence arises. Therefore, the gift can be held wide. Suppose because by the forcefully, if it make it out because of the fiduciary relationship would be there at the time, the gift will be wide. It is clearly mentioned. So for the non-Muslim, what do we do? Yes, a gift will be given to the non-Muslim. Yes, true. Whatever the unsound mind and manner, yes, they can accept the gift through the guardian. Father is the guardian appointed with the father, or father's executor, as we studied in the when you say the type of the guardians. And a juristic person includes the firm, a corporation, a company, or association, or union, or university, any other organization. A juristic person is presumed to be an adult of a sound mind, like a human being in the eye of law, and hence is a competent donee in case of the favor of gift can be made. A gift in favor of the mosque, temple, or a school is a valid. That's what I want to say. And the two or more donees, yes, they will share. A donee may be an individual or a class of persons. In case of the donee, the group of the people, all the people in that particular group must be ascertainable. The subject matter of the hiba, yes, there should be something should be there, tangible or intangible. Islamic law does not make any distinction between the ancestral and self-acquired property, or between the movable property and the immovable property. With the all property is a one property, whether it is movable or immovable, whether it is tangible or intangible. Both the incorporeal and corporeal property can be the subject matter of the hiba. Similarly, a gift can be made of the property or lease or property of the attachment or any actionable claim or like the concept of the will or wasiyat or Islamic law in which one third of the total property may be bequeathed by will. It is about the will. But in the case of the gift is concerned, a person can donate the entire property that is theoretically, but he cannot do so because he is having the kith and children, and he cannot disinherit those legal heirs. The hiba or a gift can be made with the entire property, even disinheriting the own family. It is only theoretical, but practical none, as I told you. Though these cases were decided on the Hindu and Muslim law respectively, they illustrate the principle. In Calcutta, it was held that the release of a debt is not a gift. Yes, I told you that as a gift must be tangible property. It is submitted to the reason of the debt is not a gift. It does not involve the transfer of property, but it's merely a renunciation of the right of action. Suppose somebody is having the say about the 1,000 due. So in the 1,000 due, the worth, if you give the gift to him, it is not supposed to be a gift. It is only the renunciation of the right of action and setting of the debt only. Yes, I don't know whether the people are following or not because I'm going with the bullet train speed because it is a repetition. And moreover, that you can see the my earlier videos because I prepared, I made at least twice repetition of the family law in the pandemic time. So you can find it, the Muslim law, my videos, just type my name, the subject matter, and then I'm sure that you will get the link automatically. So subject matter that I told you, no, whether a movable property or immovable property or these are the other things. Where a house, these are all the things will come. And who owns a house makes a gift to be for the house, and the right to use a staircase is used by him jointly with the owner of an adjoining house. The gift of ace is an undivided share. In the case of the staircase, is not capable of division, therefore it is called. There you can say musha. That is the wording that musha can be used over there. According to Hanifila, the gift of an undivided share in any property capable of the division is with certain exceptions incomplete or irregular, and although it can be rendered valid with the subsequent separation and delivery of possession. For instance, A makes a gift of her undivided share. I repeat, A makes a gift of her undivided share in certain lands to B, and the share is not divided off at the time of the gift, but is subsequently separated and the possession thereof is delivered to B. The gift, although irregular, facet in its inception, is deemed to the valid by the subsequent delivery of the possession. Yes, because at the time it is not there, but later on it will be there because of the separation and mutation. Yes, that is a valid gift. Exceptions again, gift of such an undivided share is a valid, which is incapable of division. When you say the incapable of division, at that instance can be made valid, but if it is easily divided, would be there, such a thing will not be there. So A, B, C, D, these are the things which I have given exceptions. If you are by one co-heirs to other, for instance, a Muslim woman died, leaving a mother, son, and a daughter. A Muslim woman died, leaving a mother, a son, and daughter. The mother made a gift of her unrealized one-sixth share to jointly to the deceased son and daughter. The gift was upheld by the Privy Council because it is going to be made later part. The hiba of a share in the freehold property in a large commercial town. For instance, A wins a house in Dhaka and he makes a gift of one third of his house to B. The property being situated in a large commercial town, the gift is valid at that instance. Again, the hiba of a share in the zamindari or taluka, according to the Amir Ali, the doctrine of the musha, is applicable only to the small plots of land and not the specific shares in large landed property like zamindari. Of course, now there no question of zamindaris are there. Thus, if A and B are co-sharers in zamindari, each having a well-defined share in this rent of undivided land, and A makes a gift of his share to B, there is no regular partition of the zamindari, the gift is valid because at the time, yes, if it is made later on clear by the mutation, then we can say it is a valid gift. The hiba is share in a land company, it is also a valid gift. Muslim law recognizes the difference between the corpus and the usufruct of the property. Corpus or ion means the absolute right of the ownership of the property, which is heritable and unlimited in point of time, while the usufruct, that is called a manafi, means usufruct means suppose the crop is there, the usufruct of a crop, the mango grove is there, the usufruct of the mango grove is the mangoes. Means the right to use and enjoy the property. It is limited and is not heritable. So we cannot be the owner of the property, but you can only enjoy the property. That is the usufruct of the property. Then that is say we'll say manafi in the family law terminology. That is the Muslim law terminology. The gift of the corpus of the thing is called hiba, and the gift of only the usufruct property is called aryan. So aryan, not aryan, aryan. That is the manafi as well. Usufruct is manafi, you will say. So Nawaz Ali Khan versus Ali Raza Khan, it was held that the gift of usufruct is a valid in Muslim law, and that is the gift of the corpus is subject to any such a limitation imposed due to the usufruct being gifted to someone else. He further held that the gift of the life interest is a valid and it does not automatically charge into the gift of corpus. The ruling is applicable to both the Shia and Sunni law. So that is the case law where it clearly says that the subject matter of the gift, if it is unpartitioned also, that it can be given, or if the usufruct also it can be made in the form of a gift, that is the subject matter of the gift. Hence, the critical scrutiny of the concept of the gift under the Muslim law gives us the following instances regarding what can be the subject matter of the hiba. So, what is the subject matter of the hiba? Then, the number one, anything over which the right of property may be exercised. Yes, that also can be given in the form of a gift, or anything which may be reduced to position. Yes, we can take position, which is a tangible thing. Anything which exists either for the specific entity or an unenforceable right. Yes, anything which comes within the meaning of the word mal. Mal means property, here I told. So Rahim Bucks versus Muhammad Hassan, it was held that the gift of service is not a valid. Suppose the services in the form of a gift is not a valid because it does not exist at the time of the making the gift. So whenever the person is making the gift, and you see that such a subject matter should be in existence. If not rightly over there, but after sometimes like the partition, if the mutation is taken over there, then it can be a valid gift. Formalities in the mode of gift. What other formalities should be followed over there? Out of all the conditions mentioned in this necessary, that the essential of hiba is that a Muslim law must be satisfied. What is satisfied? More presence of the party is not enough. There are certain formalities necessary for the real and test of the valid gift. These three conditions are discarded. A declaration by the donor, as I told you earlier, and next is there is express declaration or implied declaration. Then acceptance by donee. Yes, I tell you, two or more donee, they should be accepted over there. And delivery of position by donor by taking the position of the donee. Yes, it must be there. And the difference between the delivery, how affected the movable property. Movable property can be just transferred by giving the physical position of the movable property to the donee. But the immovable property is concerned, it should be transferred through the transfer deed. That is only the thing. Let us see the what is the Nur Jahan versus Muftahar. A donor made a gift of certain property to the donee. Okay, but a donor continued to manage the property and take the profit himself. How could he make it a profit? Because he could not take the profit once the property is given to the donee. Till the death of the donor, no mutation was made in the name of the donee. It was held by the court that since no delivery of the position was made, the gift was incomplete and ineffective in nature. How could a person will give the gift when he enjoy the usufruct of it? And there is no specific time will be given over there, and such a gift will not be called a valid gift and is ineffective in nature. That is observed in the Nur Jahan versus Muftahar in the case law. So delivery is important or not? The point is it is a very important. Under the Muslim law, where the mutation of the proceedings have started, but the physical position cannot be given by the donee, donor dies. At that instance, the gift fails for the want of the delivery of position. However, in such cases, if it is proved that although the mutation was not complete and the donee was already taken the position of the property at the time, the gift was held to be valid. So that is the point which I want to make it out in this class. And today I have posted the gift. Not. I will post the gift as soon as the class is over, where we can make it. Kinds of gifts are there because the time is very much less, and that's why I could not complete the kinds of gift. Baba Hibabil was there, Hibabil Sharatul was there, Sadha is there, Arya is there. Then I will post it to in your what's a group app, including my YouTube upload also. You can watch and hear and the thing. So only the kinds of the gift I have not made it, but I will post it and you can read. And but a reading doesn't make any sense. The point is explanation is the very important factor, because there should be something I could ask, something you could give, and that will be a quite good mode of learning. That is the participatory class. You will say in one word, in another word. So this thing I would like could not find, because I already made the three videos or two videos earlier regarding the gift is concerned. Please enjoy those videos, though are not like the bullet train speed like what I did today. It is a slow and motion videos. Perhaps that will be quite good to you. That is what I want to say. And revocation of the gift and delivery of the position and the kinds of the gift, and later you say the last point difference between the Shia law and the Sunni law, how the gift would be there. The Shia law of revocation of gift differs from the Sunni law in the following respect. First, a gift can be revoked by a mere declaration on the part of the donor without any proceeding or in a court of law. Secondly, a gift made to the spouse is revocable, and thirdly, a gift to relation to whether within the prohibited degree of the not is revocable. The Shia law does not recognize the principle of musha. According to Shia law, a gift of a share of the divisible joint property is valid even it is made without partition. Okay, gift to the minor. I already told you on behalf of the minor, somebody should have to accept the gift, that the legal guardian. Since the Muslim law reviews the law of gift as a part of the law of contract, there must be an offer that is called ijab, then acceptance that is called hubul, and the transfer that is called khabza. So these are the things should be there. Let us see this SMT Hussein D versus Hussein Saab Hassan, a grandfather made an offer of a gift to his grandchildren. He is also accepted the offer on behalf of the minor children. However, no express or implied acceptance was made by the major grandson. Karnataka High Court held that since the three elements of the gift were not present in the case of the major grandchild, the gift was not valid. It was valid in regards to the minor grandchildren, but not to the major grandchildren. For the purpose of the acceptance of the gift, the guardian of the minor or insane donee is under the order of priority. The whole will accept on behalf of the donee if the donee is a minor. Number one, father. Next, father, executor. Next, paternal father. Next, paternal father, grandfather's executor. This is the hierarchy would be followed when the donee is a minor. It is to be noted that the mother is not recognized as the guardian of the property of her minor child. Hence, she is not entitled to accept the gift on behalf of her minor child, but she may be only the custodian of the child. Where a gift is made to a minor or a lunatic, a gift is a completely only if the guardian is taken an actual or constructive delivery of the possession of the property on behalf of the person. Suppose the donee is a minor. At the time, the legal guardian should have to take the acceptance of the gift. If the possession is taken by any other person who is neither a legal guardian nor the de facto guardian, that becomes ineffective and void. Suppose the possession is given either taken by either the neither a legal guardian nor a de facto guardian or any other guardian appointed by the court at the time, the gift becomes ineffective and void. So these are the things which will come across in one of the case law, that is Katisa Umman versus Naravanat Kumaha Muand. That is a case law where it is said, in this case, a Muslim husband made a suggested gift to his wife who was a minor. The gift was accepted by the donie's mother. Unfortunately, after 2 years, the husband died. Soon after, its donee wife also died. The validity of the gift was challenged by the elder brother of the donor husband on the ground that there was no delivery of the possession as a gift of a minor accepted by her mother, who is not a legal guardian according to the Islamic law. But the issue is, the question before the court was whether the gift made with the Muslim husband to his minor wife as accepted the mother on behalf of the minor's wife is valid or not. The court in this case held that it is a well established rule under the Islamic law that mother is not a legal guardian or of the minor's property. Therefore, she is incompetent to take the delivery of the possession on behalf of the minor donee. But in case there is no legal guardian to accept the gift, the completion of the gift for the benefit of the minor was at most significance. If the donee had already attained the age of puberty, the gift is valid if it is accepted by the person who has authority to accept the gift on behalf of a minor. In this case, a gift was held to be the valid, although the delivery of possession was not accepted by any competent guardian on behalf of the minor. But since the minor had reached the age of discretion, that is the 15 years, and was competent to accept the gift herself. So now the question comes over there whether what is the age for the guardian, in the, especially the gift is concerned. But generally, we will take into consideration 18 years. But in certain exceptions, if the 15 years girl also will have such a knowledge that what she is doing, what she is not doing, at the time also the court will take the best interest of the child. They make the gift as a valid gift. So, but generally it will not be there. But in case of necessity, yes, it can be made on behalf of the mother, on behalf of the child who is the minor, on behalf of the child as a guardian who is their mother, who actually is the custodian of the child, but she can accept it. And when the child becomes a major at the time, it can be repudiated or it can be accepted. Then the discretion will be given to the child. So whenever the delivery position is not necessary, of course, delivery position. Suppose the donor itself is residing in the house, then there is no question of giving the delivery of position. So the donor and the donee have jointly in the gifted house at the time where the subject matter of the gift is a house in which the donor and donee both resides together. Of course, donor also there, donee also there. Any formal delivery of the position not necessary at the time. Because since the donee is already continuing the position of the house in some other capacity, there is no need to give the donee of the same position again the different capacity. But there will be some conspicuous act or apparent activity on the part of the donor and indicate the bona fide intention of the donor to transfer the position. Of course, I have cited the case law here. That is the case law is Humaira Bibi versus Najmun Nisa. A Muslim lady executed a gift deed of her house in favor of her nephew. That is the spelling is Nephew. Either it's a nephew or nephew who was living with her in the same house. The property was transferred the name of the nephew, but she continued to live with him as the before. But after the making the gift, the rents were collected in the name of the donee. It was held that the gift was valid, although there was neither any physical transfer nor to the donee nor any physical departure of the donor from the donee, because both are residing, donor and donee residing in the same house. So that was the thing. And next part is it says the gift by a husband to a wife or a vice versa. So where a gift of immovable property is made by the husband to the wife or vice versa, to transfer the position is a mandatory. The reason behind this is the joint residence is an integral aspect of the relationship of marriage. And to perform the matrimonial obligation, it is necessary that the husband and the wife must live together. So that is another point of the thing. So with this, I would like to stop it because the time is also over. So a gift by guardian to award, there is something, Doctrine of Musha, it can be asked in the short questions, Doctrine of Musha, where the property is indivisible at the time, the gift may be valid. That is the thing. The word Musha has an Arabic origination with a literally meaning the confusion under the Islamic law. Musha denotes the undivided share in the joint property. It is therefore the co-owned by the joint property, co-owned or joint property. One of the several owners of the property makes a gift of his own share. Thereby arises the confusion in regard to what part of the property is to be given to the donee. Practically, it is too difficult to deliver the position of the joint property if a gift is made for the donor without a partition of the joint property. To circumvent such a confusion, the Hanafi jurists have developed the doctrine of Musha, the gift of the property, gift of the Musha, that is the gift of the share to the owned property is invalid without the partition actual delivery of that partition property to donee. If the co-owned property is not capable of the partition, the doctrine of Musha is impertinent. A Musha is undivided property of the two kinds. Musha indivisible and Musha divisible. So these are the things. And how it can a comparison of the gift and will. So here I have given the chart. You can take the screenshot, the quantum, beneficiary, existence of property. Meanwhile, you can take the screenshot so that it will no need a plug-in for another power. It is saying so. I have to plug it. Otherwise, it is going to be stopped. So again, you can take the screenshot of this also so that you could know what is the distinction between the Shia and Sunni law in the form of a gift, and this is the total conclusion I would like to make it out. So this is the conclusion. Since that also you can take it so that you could know that what is given in the conclusion, and the voluntary professor of law and his mobile numbers are given over here. Thank you very much for patient listening, and I would like to close it. And I would like to say thanks to you also. That is thank you sign here. With this, I will stop it, and tomorrow class I will post you what I am going to make it out. I am sure that tomorrow we have the examination, but my class is in the morning. Okay. And you now you tell me that which part that I would cover tomorrow. Anyone? Quick, quick.
Thank you, sir.
Yes, which part I have to cover tomorrow morning? Quick. Sorry, your choice.
Yes, sir.
Okay, okay, it's okay. End of the meeting, and we'll meet you tomorrow.